Hello and welcome to LiveLaw Daily. Today is the 17th of July and these are the biggest legal developments from courts across the country. From the Supreme Court's latest rulings to important orders from the High Courts. Here's everything you need to know. So let's begin. For our first story today, the Allahabad High Court has clarified that an election tribunal cannot examine the validity of a caste certificate or declare it to be forged while hearing an election petition. Justice Neeraj Tiwari held that once a caste certificate has been issued by the competent authority, it can be scrutinized only through the statutory mechanism created by the state government. The court observed that district, regional, and state level scrutiny committees alone have the authority to validate or invalidate caste certificates, and that an election tribunal has no jurisdiction to undertake that exercise. The ruling came in an election petition challenging the victory of Vinay Prakash, who is an MLA from Uttar Pradesh's Ramkola Assembly constituency. The petitioner alleged that the MLA actually belonged to the other backward class and had fraudulently obtained a scheduled caste certificate to contest from a reserved seat. He argued that the election tribunal was empowered under the Representation of the People Act to examine the genuineness of documents submitted with nomination papers, including the caste certificate. The High Court rejected that contention, holding that the law provides a self-contained mechanism for deciding disputes relating to caste certificates. It said that a certificate duly issued by the competent authority remains valid unless it is cancelled by the designated scrutiny committees. Therefore, neither the returning officer nor the election tribunal can question its validity during election proceedings. The court also relied on the Supreme Court's decisions in Kumari Madhuri Patil, Dayaram versus Sudhir Batham, and A. Raja versus D. Kumar, which consistently hold that challenges to caste certificates must be pursued before the statutory scrutiny committees, with judicial review available before the High Court under Article 226 only after those authorities have taken a final decision. The challenge to the MLA's caste certificate will now continue before the competent scrutiny authority, while the High Court has made it clear that the issue cannot be decided as part of an election petition. For our second story today, the Madras High Court heard a petition alleging that appointments of government lawyers in Tamil Nadu were manipulated, with posts allegedly being sold for between 5 lakh rupees and 30 lakh rupees. The petition was filed by Gyan Sundari, who is the Joint Secretary of the TVK District Advocates Wing in Viluppuram, who claimed that she had applied for 2 prosecution posts but that her applications were never acknowledged by the District Collector's office. She told the court that CCTV footage from the Collectorate would show that she had personally submitted the application. The petitioner further alleged that a WhatsApp message containing the final list of selected candidates was circulated at 12:11 p.m. on June 29th, even though the official deadline for submitting applications was 5:45 p.m. the same day. She claimed that the list consisted largely of lawyers affiliated with the DMK and the ADMK, and alleged that appointments were made on the basis of political recommendations rather than a fair selection process. She also claimed that members of the legal fraternity had informed her that 5 lakh rupees to 30 lakh rupees had been collected for each appointment. The plea named several officials and political leaders, including the Law Department Secretary, the District Collector, and TVK General Secretary N. Anand, alleging that they were responsible for the irregularities. However, Justice Muhammad Shafiq questioned whether the WhatsApp message alone could establish that appointments had already been made, asking, how can you say that because X, Y, or Z circulated a list, the appointment was made? Was there any appointment made? Appearing for the state, the Advocate General informed the court that only temporary appointments for 6 months had been made because the previous tenure of government advocates ended on June 30th, and that all applications, including the petitioners, were still under consideration. The court also observed that Chief Minister Joseph Vijay, N. Anand, and the local district secretary were not necessary parties to this proceeding, remarking that they appeared to have been impleaded in the case merely to attract headlines. The matter will now be taken up again as the selection process continues. And for a third story today, the Supreme Court expressed concern over allegations that people in West Bengal are losing access to welfare benefits even while their appeals against exclusion from the state's Special Intensive Revision or SIR remain pending. A bench of Chief Justice of India Suryakant, Justice Joymalia Bagchi, and Justice V. Mohana was hearing a petition seeking a more efficient appeal mechanism for those excluded during the voter roll revision exercise. Appearing for the petitioners, Senior Advocate Gopal Shankar Narayanan told the court that more than 34 lakh appeals are pending before just 19 appellate tribunals, with 2 tribunal judges having already resigned. He also pointed out that of the nearly 38,000 appeals decided so far, around 70% have been decided in favor of the appellants, suggesting that a significant number of exclusions may have been incorrect. The petitioner further argued that despite these appeals remaining undecided, many people have already begun losing access to public distribution system rations, welfare schemes such as the Annapurna Yojana, and even caste certificates, causing serious hardship before their legal rights are finally determined. Responding to these concerns, Justice Joy Malia Bagchi referred to the Supreme Court's earlier judgment in the Bihar SIR case, observing that exclusion from the electoral rolls does not automatically affect a person's citizenship. He said that the Election Commission's role is limited to preparing electoral rolls and that questions relating to citizenship must ultimately be decided by the central government under the constitutional framework. The petitioners also urged the court to direct the centre and the Election Commission to make public a standard operating procedure prepared by the three-member Judicial Committee and argued that possession of a valid passport should be treated as a strong evidence of citizenship. The matter will now continue before the Supreme Court. For our fourth story today, the Karnataka High Court has granted bail to a software professional accused of abetting his wife's suicide in a dowry death case, observing that allegations of dowry demand become difficult to be believed when the marriage itself was a love marriage. Justice S. Vishwajit Shetty was hearing the husband's plea in a case registered under the Bharatiya Nyaya Sanhita and the Dowry Prohibition Act. According to the prosecution, the accused was arrested after the deceased woman's mother alleged that her daughter had been subjected to dowry harassment following the couple's marriage in 2023. While considering the bail application, the court noted that the husband and wife had married with the consent of their families after being in a relationship and were living by themselves in a rented house in Bengaluru. The investigation had also found that the other family members named in the FIR were not residing with the couple. In that backdrop, the court observed that the allegation of a demand for dowry at the time of the marriage and further demands thereafter became difficult to be believed. At the same time, the court noted that the post-mortem report showed that the deceased had suffered a minor injury on her lips, which prima facie suggested that the couple had an altercation immediately before the incident in which she took her life. The High Court also took into account that the investigation had already been completed and that the accused was responsible for the care of the couple's 2-year-old son. On these considerations, it granted bail subject to conditions including furnishing a 1 lakh rupee personal bond, appearing regularly before the trial court, and refraining from influencing witnesses or committing a similar offense. The criminal trial in the alleged dowry death case will now proceed on its merits. For our fifth story today, the Patna High Court has granted bail to one of the accused in NEET paper leak case, observing the circumstances in which his name surfaced during the investigation. The case relates to the alleged paper leak that triggered nationwide controversy over the conduct of the NEET examination. According to the prosecution, police intercepted a vehicle carrying 4 men along with documents, mobile phones, and other electronic devices. During the investigation, the accused allegedly disclosed that they had been sent by the alleged mastermind to collect question papers from a bank and deliver them to examination centers. Seeking bail, one of the accused argued that his name did not appear in the original FIR and that he was implicated only later on the basis of the confessional statement of a co-accused, Shashi Kumar. The state opposed the plea, pointing out that the petitioner had a criminal history involving 2 other cases. After considering the submissions, Justice Ashok Kumar Pandey granted bail to the accused. The court directed that he be released on furnishing a bail bond of 10,000 rupees along with 2 sureties of the like amount. The order comes as the larger investigation into the alleged NEET paper leak conspiracy continues, with multiple accused facing prosecution in the case. For our next story today, the Supreme Court has taken a suo motu cognizance of the issue of access to life-saving medicines after expressing concern over the prolonged delay in a similar case pending before the Kerala High Court. A bench of Chief Justice of India Suryakant, Justice Joy Malia Bagchi, and Justice V. Mohana issued notice to the Union Government and requested the Chief Justice of the Kerala High Court to ensure the expeditious disposal of a writ petition that has remained pending for more than 4 years. At the outset, the Chief Justice remarked that the High Court matter had been adjourned repeatedly and later noted that although it had been listed for hearing 57 times, it was still awaiting a final decision. During the hearing, it was also pointed out that the original petitioner had passed away while the case remained pending. Appearing for the state of Kerala, Advocate Aljo Joseph informed the court that the state government has since imported the cancer drug in question to make it available to patients at affordable rates. Senior advocate Anand Grover, appearing for the deceased petitioner's husband, argued that the issue extends far beyond one medicine, pointing out that many life-saving drugs remain prohibitively expensive because of patent protection. He submitted that although the Patents Act empowers the union government to issue compulsory licenses to allow affordable production, only one such license has been granted since 2005. The original petition before the Kerala High Court sought a government use license under Section 100 of the Patents Act for the affordable production of ribociclib, a patented breast cancer drug. Although the High Court later converted the matter into a suo motu public interest litigation after the petitioner's death, the Supreme Court observed that the continued delay had compelled it to step in on its own. The issue of affordable access to life-saving medicines will now be examined by the Supreme Court alongside the proceedings pending before the Kerala High Court. For our next story today, the Supreme Court has ruled that the railways cannot be held liable for the short delivery of goods booked at the owner's risk rate unless negligence on its part is established, particularly where railway officials never counted or weighed the goods before transportation. A bench of Justice Sanjay Karol and Justice Vipul Pancholi dismissed an appeal filed by Bajaj Trading Company, which had sought compensation after alleging that 1,742 bags of salt went missing during transportation from Gujarat to Assam. And according to the appellant, it had booked 40,444 bags of salt, but only 38,702 bags were delivered at the destination. Although the railways issued a shortage certificate, it denied liability, pointing out that the consignment had been booked at the owner's risk rate and carried a set to contain endorsement, meaning railway officials had not verified the quantity loaded into the wagons. The company argued that the railways remained responsible under Section 93 of the Railways Act and should have supervised the loading process. However, the Supreme Court held that Section 97, which specifically governs consignments booked at the owner's risk rate, overrides the general liability provision. The court clarified that in such cases, the railways can be held liable only if negligence or misconduct is proved. Explaining the principle, the bench observed that such a duty would arise only if railway authorities had themselves counted or weighed the books before transit. Since that had not happened in this case, the railways could not be expected to guarantee the quantity delivered. The court also found that the appellant had failed to produce sufficient evidence to establish the exact quantity entrusted for transportation. Finding no negligence on the part of the railways, the Supreme Court dismissed the appeal, reaffirming the limited liability applicable to consignments transported at owner's risk. For our eighth story today, the Kerala High Court was told that the 2026 Wayanad landslide, which struck the Kalladi tunnel construction site, was not unforeseen but foreseen, with repeated written warnings allegedly ignored before the disaster. The submission came from senior advocate Ranjit Thampan, who is assisting the court as amicus curiae in the High Court's ongoing suo motu proceedings on disaster management. Appearing before a division bench of Justice A.K. Jaishankaran Nambiar and Justice Preeta A.K., the amicus stated that the Wayanad District Disaster Management Authority, or DDMA, had warned the executing agencies 5 times in writing about the dangerous accumulation of excavated earth near tunnel portal and had directed that it be removed to prevent a disaster. According to the report, those warnings were never acted upon before the collapse on July 7th. The report also questioned a June 3rd, 2026 decision of the State Executive Committee of the Kerala State Disaster Management Authority, which had taken the view that disaster management authorities had no role in overseeing projects that had already received environmental clearance. The amicus argued that this interpretation is legally unsustainable, submitting that the Disaster Management Act of 2005 creates an independent statutory duty to identify and mitigate disaster risks, regardless of whether a project has environmental approval. The report further alleged that the tunnel project violated several conditions attached to its environmental clearance, including requirements relating to muck disposal, worker safety, landslide monitoring, and coordination with disaster management authorities. It claimed that nearly 1 lakh cubic meters of excavated soil remained piled up near the entrance of the tunnel instead of being transported to approved disposal sites, despite repeated warnings from the DDMA. The amicus has urged the High Court to examine possible violations under the Disaster Management Act, the Environment Protection Act, and the Bharatiya Nyaya Sanhita, while also seeking an independent geotechnical safety assessment and suspension of construction until safety concerns are addressed. The matter has now been adjourned by 2 weeks after the state sought time to process compensation claims for the victims. And finally today, the Madras High Court has held that WhatsApp chats and screenshots allegedly showing a parent's drug use or attempts to procure narcotic substances can be considered in child custody proceedings, despite privacy concerns if they have a direct bearing on the child's welfare. Justice A.D. Maria CLAT made the observation while hearing a guardianship dispute in which a mother sought permission to place on record chats and screenshots that she claimed showed the father's drug use, drug-related conversations, internet searches on narcotic substances, and an alleged relationship with another woman. The father denied the allegations and disputed the authenticity and source of the material. The documents had initially been refused by the Master of Court on the ground that they had concerned a person's privacy. However, the High Court held that the welfare of the child is the paramount consideration, and material that has a real and direct bearing on the parent's fitness cannot be excluded merely because it originated from private communications. At the same time, the court clarified that not every private message becomes admissible in a custody dispute. It said that there must be a clear connection between the material and the child's welfare, and the evidence cannot be used to simply embarrass a party or widen the matrimonial dispute. And that's all for today's edition of LiveLaw Daily. If you'd like to read any of these stories in detail, you'll find the links in the description box. For continuing coverage of the courts and the law, visit livelaw.in. Thank you for listening and keep following LiveLaw to stay updated with everything that is law.